While we wait for that potential indictment in the other federal case against Donald Trump, the charges against him for mishandling classified documents, including nuclear secrets, after leaving the White House. Yesterday, the recently named third defendant in the case, Mar-a-Lago property manager Carlos de Oliveira, made his first appearance in a Miami court. De Oliveira was charged with 4 counts related to his alleged efforts to erase security camera footage at Trump's Palm Beach home, which was monitoring a room where boxes of classified documents were being stored. That's according to prosecutors. The order to destroy the footage came from Trump directly and was given to both De Oliveira and the former president's valet, Walt Nauta. Trump has denied ordering the footage be deleted. Because De Oliveira has not yet hired a Florida-based attorney, he did not enter a plea yesterday. He was released on a $100,000 bond and is due back in court on August 10th for an arraignment. Let's bring in former U.S. Attorney, MSNBC contributor Barbara McQuade. Barbara, good to see you this morning. Because there is so much going on, we'll remind our viewers that Mr. De Oliveira is the property manager at Mar-a-Lago, named in that superseding indictment that we got last week that suggested he was directed by Donald Trump, according to prosecutors, to go find the tape, delete the tape that could show security footage, perhaps of people moving classified documents around, and that Donald Trump then checked in on him to make sure he was still good, that he was still loyal. You're still on our side. You're not going to flip. So what did we learn yesterday, if anything, from that hearing, and how central a figure might Mr. De Oliveira be in this case?
Well, Willie, the appearance yesterday was rather routine, which they often are. We did learn that he has not yet secured a lawyer, which means that his arraignment will have to be delayed until that can happen. And I think that it does build in the possibility of more delay in the ultimate trial date, that May 20th trial date. The longer it takes for him to get a lawyer, I imagine it will cause them to ask for additional time. I don't know whether they'll get it, but I think that is a possibility. And how important is he? I think he is very important. He adds to this dimension of obstruction of justice. And that is, after all, what makes this case so different from other cases involving inadvertent retention of classified documents. You know, the case with Mike Pence, the case with Joe Biden, where upon discovery, they alerted the authorities and returned the materials. Here, this shows a deliberate effort to cover up the movement of boxes, which was part of the effort after Donald Trump was engaged with the government over the return of the documents. Instead of returning them, he reviewed them all, and the movement of boxes was captured on video, which the government later was able to obtain. So I think he's a key witness because he is the one who pulls all of that together. And another new figure introduced in that superseding indictment, Barbara, is what was known in the document as Trump employee number 4. CNN is reporting that he's the IT worker who was working with Mr. De Oliveira, and De Oliveira came to him and said, hey, I need you to delete these security cameras, the tapes of them anyway. And he says, well, I don't think I can do that. So in the indictment, it doesn't look like he's being charged with something. Could it be possible that he is cooperating with the government in this case? Yes, that would appear to be the case. You know, that word cooperating is a term of art in prosecution and often means it's someone who has some criminal exposure and has agreed that in exchange for providing information, they will either get a lenient sentence or not be charged at all. It appears that employee number 4 will not be charged at all because he's not named in the indictment and he's not charged. And in fact, it looks like he did what you would hope a person would do, which is to decline to engage in obstruction of justice. You know, we have focused on the people who allegedly have violated the law in their loyalty to Donald Trump in the form of Walt Nauta and Carlos de Oliveira. But there are other people, these people named as just Trump employee X, Y, or Z, who actually did the right thing and have not complied and appear that they have testified at the grand jury because we know from their testimony about some of these facts. So I think employee number 4 could end up being a very key witness in all this. And he did receive a target letter, but not charged in the case. So we'll keep an eye on him as well. So we've covered the 2 federal cases against Donald Trump. Let's move to Georgia, where a judge has denied yet another attempt by former President Trump's legal team to stop the investigation by Fulton County DA Fani Willis into alleged interference in that state into the election in 2020. This is the second ruling against the Trump team in as many weeks. A third petition to the court is scheduled for an August 10th hearing. In a 9-page ruling, the judge found neither the former president nor
one of his allies, also challenging the probe, had the legal standing to quash the investigation. In an interview over the weekend, Willis confirmed her probe is in its final stages, saying, quote, "We are ready to go." So, Barb, if you read this 9-page ruling by the judge, it's pretty forceful. It's a smackdown, if you'll forgive the term, of these lawyers. Frankly, he's saying you're gumming up the system. These are not credible claims to get rid of this investigation completely. It will move on. And just like the Supreme Court in Georgia did last week, telling effectively Trump's legal team, this case is going forward.
Yes, I mean, until you're charged with a crime, you really don't have any standing to say, I can't be charged with a crime. We don't even know what the indictment might allege, if any. And so the time to file motions attacking charges or even the validity of a grand jury or the process there is after those charges are filed. And I imagine that Trump will file many of those motions afterwards. But the idea that you can do it prematurely before you've even seen what potential charges are there is just not ripe. It's not ready. So I think most legal experts expected to get this ruling, but I think what's valuable is that the ruling came now so that there is no uncertainty for Fani Willis to be able to go forward. The last one remaining relates to her own recusal from the case. Again, I don't see any reason to expect that that one will be granted, but even if for some reason it does, there'll be some assistant who's ready to go forward. So this case is going forward one way or the other, and the time to attack it will come later.
And Fani Willis, the DA has said August, and here we are in August now, ready for that. So we will see.